I'm James Lowe. We've talked before about some of the issues that confront people, and this one is about what clocks are ticking on your rights if you are injured by a dangerously defective or unreasonably dangerous product, like a motor vehicle, for example, or really any kind of product. There are two clocks that are ticking, and you need to be aware of them. The first one I think most of you know about, and that's any case, whether someone is injured or killed, must generally be brought within 2 years of the date of injury. That doesn't apply to medical malpractice or some other kinds of cases, but it applies to all of the product liability type cases. If your product is defective, you have 2 years from the date of injury. But there's another clock that's ticking, courtesy, I'm afraid, of the Ohio legislature, which passed a law that said any product that is more than 10 years old when it causes injury or death is somehow off the hook completely, no matter what the defect might be. So for example, if a transmission is defective and allows the vehicle to roll over somebody in a rollaway situation, and it's more than 10 years old, no case. If the airbag doesn't go off when it should have, no case if the car is more than 10 years old. And here's something you really need to be aware of. You can't control, if you've owned a car for 10 years, you can't control that as to whether or not a defect could cause injury. But when you go to shop for a used car, that's something you really need to be thoughtful about. If you're buying a car that is already more than 10 years old, you're buying a car that has no liability, even if it is absolutely defective and causes injury or death. So we just want you to know. That's why we're here. Please feel free to give us a call or email us anytime you want. Thanks for listening.